There is quadruple I 1 through 29A. What's I guess? They all have A's, which are the video or audio recordings, and triple I 31 through 35A are also audio recordings. So only 30A is a text instead of an audio recording.
To be clear, there are no listening devices.
There are no listening
aids.
Yes,
sorry.
there are.
So you have 1 through 35, which are standalone, and then you have 1 through 29A. That's 1A through 29A, which are audio recordings. 30A is a text, and 31A through 35A are again audio.
Yes.
Recordings.
With one exception, Your Honor, there is no 10A.
Okay.
Sorry.
There's a 10A, which is what?
There is no 10A.
Oh, there is no 10A. Okay, all right. So are the 31 through 35? Those are what?
That's the PowerPoint, Your Honor.
Okay.
It's the index of the recordings.
Judge, as the court will recall, we had a motion to suppress, so we will maintain those objections with respect to these various items. And I think we had a lengthy discussion during trial about which ones would be admitted and which ones weren't. And I believe some of these were admitted previously over our objection. So we want to maintain those objections that we made previously.
No objection to quadruple I1. We object, and so all that is, what quadruple I1 is it contains a target name, telephone number, date of order, extension. That you don't have an issue with. It's quadruple I2 through 35, which are the date and time of call information, and the context. And we've consistently objected to the context. We object to that. It has it here on all of these. If the jurors want to listen to it, they need to listen to it and determine what context they want to listen to it. Therefore, we're not objecting to the audio report. If they want to listen to it, listen to it. Whatever conclusion they draw, let them draw. They shouldn't have to see the context that's been provided. And so for that reason, we object to those documents.
Your Honor, for the record, as we were doing this, I gave them each one of those that you're looking at now, and they did not have an objection while we were presenting it. So I don't know how there's an objection now. They basically approved the content, didn't object to any of the content because it is,
This is the one, remember you said I want the defense shown each one of those before I put them up there.
Yeah.
And then once we started doing that, we didn't really get any objections.
To be clear, we did file a motion to suppress, which would exclude all of these. And we stand by that motion, which would cover these documents as well.
you are objecting to what again? Let me make sure I've got your objections down. You're objecting to all of them or part of them?
This stack, just this stack.
So that's 2 through 35?
No objection to 1, and if that's 2 through 35, yes.
No objections to quadruple I1?
No objection.
All right. And you are objecting to
Just those, those documents, 2 through, I think it's 35.
that's 2 through 35.
Checking to, presumably, I mean, if the court, I don't know if the court has done it yet, but if the court admits to recordings, they have the recordings, over our objection in these documents.
So you're objecting to all the recordings as well? Is that right?
Yes, if the court recalls, we filed a motion to suppress those recordings, and so we stand by that objection. But all I'm saying is assuming the court allows the recordings, there's especially no need for these documents which we just handed to the court.
And the state's position on these documents, I don't know what you call them exactly, I guess they're...
Right. They're just cover sheets that act as an index for the jury to be able to find the recordings that they need. Again, we narrowly tailored them, and during the presentation, you wanted us to show those to the defense. Ms. Smith would walk them over, she would hand them to Mr. Nash, Mr. Nash would talk to Mr. Parker, and then he would we'd look at each other, and he'd give me a nod as to whether or not we could play it. So, again, it's just going to be used as an index to help jurors determine what calls are what with respect to if they want to listen to something.
You feel these are relevant to show up?
The date, the time of the call.
No, I mean the calls themselves are relevant
yes,
to show. They're relevant to what?
Yes, Your Honor. So again, this is something, we actually took 2 full days looking at these, where the court was provided transcripts and looked at them, the defense looked at them, we made our objections, we had our discussions, and the court ruled that these were the ones that were admissible. They were played for the jury. It shows any number of things. I mean, there's all kinds of things on there. It shows, him telling people, the defendant telling people not to talk to law enforcement. It shows him, with the whole Beth Ann situation, trying to push her out and over Jake's objections. Just various other things that were deemed to be relevant.
And there were ones in the grouping that we wanted to play that you ruled were not going to play, and actually kept us from playing. So, to a certain extent, the relevancy is raised to that.
The court will admit 1, that's without objection. That's quadruple I1 without objection. Will admit 2 through 35 over objection.
Is that with the context included?
Say it again.
Is that with the context included on the sheets?
Well, what I had previously done in these contexts, and which I thought we had covered, as one of the attorneys here for the state mentioned, I thought we had covered this during the presentation of these, is that they should be shown to you, and if you objected to something, then we would decide whether it needed to be edited in any way. There wasn't any objection expressed to the court at that time, so I'm not sure what it is you're objecting to. If they weren't objectionable then, they have become objectionable now? For some reason, is that what you're?
Judge, I think it was one thing to use the context to explain to the jury in relation to playing the actual recording, but we just object to the actual documents that now seem in context, etc. So it's not necessary to put the actual paper documents back. They'll have the recordings.
Again, assuming the court admits the recordings over an objection, what is the need for this? I mean, assuming the court admits the recordings, the jury has it, they can listen to it.
I think that the reason for 1 through, or 2 through 35, well, actually 1 through 35, would be that if a juror says, it seems to me that this person said to that person in that recording, such and such, that they don't have to listen to 35 recordings to find it. I would imagine that's the purpose of it.
So they have to rely upon that interpretation.
They would go back and listen to the tape to see whether it said what their recollection was that it said.
My problem is if they heard something, but here's the problem. The juror heard a recording. They want to go back and they want to find that recording. But their understanding of the recording in the context is different than what's on that sheet. How will they find the recording? And so therefore, those contexts, that shouldn't be there.
Well, that's why I had them show them to you before we played the tape, it's so that if you thought the context was not as on here, you could have said something at that point, which nothing was brought to the attention of the court at that time.
And Your Honor, it's also consistent with how we handled the 2017. You already admitted the identical sheet. It's just a guide. The audio recordings are the best evidence. If they go to listen to a recording and it's not it, then they'll look through the remaining list to try to find it.
Let me ask defense counsel this. Is there a particular, are any of these in particular, do you feel, because of the language used to identify the tape or the recording, in particular prejudicial? I'm looking at one here that says photos of Beth's journal. I'm looking at one that says George and Jake Wagner talk about Special Agent Scheider. So I'm looking at some of these. George Wagner talks about Beth and family. Some of these seem to be pretty much non-prejudicial, just identifying. If there's something in here specifically, any specific language that you feel is prejudicial?
Judge, we'll withdraw our objection.
So,
After further discussion, we'll withdraw our objection.
as to all of them?
Yes. Well, not that, we want to maintain our
Objection.
motion to suppress and the arguments we made previously, but with respect to the context.
Okay, these identification sheets, then?
Yes, we'll
Withdrawing your objection to
withdraw
that?
objection with
All right.
respect to the sheets themselves,
All right.
but maintain our other objections we made.
Okay, so that would be 2 through 35. And you said you no objection to 1, so now there's no objection to 1 through 35. You are maintaining your objections to 1A through 35A.
And just maintaining the previous objections we made, we went over them individually the other day.
And so these will be admitted, 1A through 35A admitted over objection. 1 through 35 admitted without objection. One A through 35A admitted over objection.
You ready for quadruple J, Your Honor?
Quadruple J.
We would move to admit quadruple J1 and quadruple J2. These are still photos from the video provided from Mr. Priest, their witness.
No objection.
Quadruple J1 and 2 would be admitted without objection. Quadruple K.
Is an application for driver's license that was shown to the board yesterday on the stand.
We don't object.
Quadruple K will be admitted without objection. Quadruple L.
Quadruple L 1, 2, and 3 are all regarding firearm purchases of George Wagner that he was shown on the stand yesterday.
Judge, with respect to quadruple L3, this is the firearm trace summary from August of 2017 concerning the red at 9mm. As you might guess, we would object.
Say it again.
As you might guess, we would object.
Yeah.
It's post-crime and a 9mm, so I think we've addressed this issue before. We do not object to quadruple L1. Judge, on further reflection, we would object to quadruple L1 because it refers to a firearm used in the crimes. And we would object to quadruple L2 as well. And 3 we've already objected to. I guess we object to all 3.
Specifically, they're firearms, not alleged.
Took me a minute to find it, but quadruple L2 is also in that motion.
State's argument as to these is,
Yes, Your Honor. First of all, as you'll recall, Mr. Parker had the defendant on the stand, and he went through all of the weapons on that list that either George owned or Jake owned or Billy owned, and Sophia and such. But so again, this is not used for propensity. The whole purpose of these is that he used a fictitious address on a federal form, which is a federal offense punishable by 10 years in prison. And these were post him, giving up a life of crime. So that was the purpose of those. Certainly not being used for any propensity arguments.
Judge, the other thing is it's not clear from my reading that just giving an address that is on a driver's license is false identification. He identified himself through his social security number, through his birthday, through photo ID, with his signature. So whether he committed a crime or not, I think is very vague and open to question. That he simply provided a good address that he had on his driver's license at the time. So I really don't think that argument.
is there a,
There is a warning on the form that
no, I mean,
says
is there a 4? I've got 1, 2, and 3.
just 3. There's just 3. There's just 3.
Oh, okay, so, I'm sorry, I thought there were 4 of them. There are 3, quadruple L1, 2, and 3. I do have a question as to one, just at the writing on the top of it there.
That's just on the form, Your Honor. That's how we obtained it.
Oh, okay.
Yeah,
So somebody scribbled it on there
transaction number.
before it got fed into this.
Yeah, that's how it came.
Taking the purchase price or
And he testified.
So-
transaction number.
Let me make sure I understand the reason the state's offering these. You're offering these to show that he had not given up a life of crime because he put down 845 Bethel Hill Road as his address on these firearm purchase forms.
Yes, Your Honor. Because he did not live there at that time. It is a federal offense to put in false information, punishable by 10 years in prison.
Plus what?
It's punishable by 10 years in prison, so it's not a small offense. And anyone who purchases a gun knows that. But also, I believe one of those is the AR-15 that then he testified that he got the scope for, again, using the cash with Jake's rewards card, even though it was he that was purchasing it, or his dad was purchasing it for him with him there. So, again, it also connects that too. In the Beretta, you've already ruled is admissible.
Well, I'm trying, again, I want to make sure I understand so that you can explain to me why these are being offered. They're being offered to show that he put down his former address rather than his current address on these firearm purchase forms. That is the sole reason for their
That
being
is
offered.
I would say that is the main reason, Your Honor. But again, that Beretta purchase, you've already ruled is admissible, and the AR-15 connects to the scope that he bought shortly thereafter, a month after he bought that weapon. And
Well, okay, the purchase of the AR-15, the purchase of the Beretta, how are those relevant to this case?
well, the Beretta is replacing the Beretta that was used, or that they initially tried to fashion a silencer for. And you've already ruled that is admissible. I mean, they continue to object to it, but throughout the case. And the AR-15, again, he testified that he had bought that weapon, purchased a scope for it. I showed him the receipt for the scope. He identified it. It was purchased with cash with rewards card, which goes to the state's argument that just because you see a cash purchase with Jake's rewards card does not mean Jake is the purchaser, because he testified that it was he and his father that were there that time. And along with using an incorrect address, which is a crime.
Anything else from the,
Judge,
yes?
the state just told you that a Beretta was used or was being used. That document shows that Beretta was purchased in April 27,
Usually
16.
replace.
Yes.
Yeah, and if we're relying upon the testimony was that Billy bought the scope. If he used the rewards of Jake, he used rewards, but that doesn't tie the defendant to that.
He said he was with him when it was purchased. That's how he knew. Billy bought it for him.
And so,
We talked about that.
speaking of his testimony, I think the testimony was that the address on his driver's license, which was a legitimate address that he lived at for many years and matched his driver's license at the time of the purchase, is what's being put on this form.
That's weight. It says making any false oral or written statement or exhibiting any false or misrepresented identification with respect to this transaction is a federal offense. And again, I don't know how this is prejudicial to the defense, given they went through and had him admit on direct that he had purchased these weapons and or owned them. And so again, it's not prejudicial, and the state feels it's highly probative because
that issue of the gun list
he
was
brought up
not
in
waived.
direct that he stopped, swore off the life of crime in 2014 or 2015, and that's clearly not true. So
Stealing fuel.
this is rebuttal evidence, if nothing else.
The claim was, I'm no longer stealing fuel. This doesn't relate to that. This doesn't rebut that.
So how many guns are represented here by these three
Just
sheets of
three,
paper?
Your Honor. Just three. And he testified.
Okay.
But the other thing is just because the gun list was brought up, the court has already indicated maybe 10 times throughout this trial that was admitted, that was permissible. Merely bringing it up on direct examination doesn't raise the issue. The court had ruled many times this gun list was coming in. And in the ordinary course of events, we would be doing this now before the defendant got on the stand. And as we've seen, the gun list has been admitted.
Well, when he testified in direct, we would have sought to use these and then move to admit it after the close of your case. This is a cross-examination.
All right, so maybe counsel's familiar with these, could approach here just a minute. We have, this one is the Beretta, I understand.
LL3 is the Beretta with the date of August 2017.
That's when it was run.
That's when firearms tracers.
Correct. That's when the purchase was in April 2000, 5 days after the homicide.
Purchase receipts, everything on that.
Should be right there.
Yeah.
And one, there's probably an identification of a
This is quadruple L1 is the purchase at Walmart of the Diamondback AR-15, which was done in August 16th of 2015. And the Diamondback SKS is not related to this crime. That was not what was found in the bucket.
Okay, so number one is being admitted solely for the purpose then of the address, or is it being admitted for some other purpose?
It is related also to the scope, Your Honor. Yeah.
And the scope is not part of the crimes act.
The scope is related in the state's view because that's what they purchased with cash with Jake's rewards card, even though it was George and Billy that were purchasing it. So, you know, and he testified to this on direct first. And then, you know, I brought up the fact that he's also using the wrong
All right, now
address.
number 2 then, what?
Number 2, Your Honor, is a purchase of the Glock G17 pistol 9mm, which was done March 17th, I believe, of 2016. Once again, it's a 9mm. He does use the Bethel Road address indicated on the front page.
All right, so other than the Bethel Hill Road address, how is this one relevant?
Yeah, that would be the relevancy, Your Honor. And again, I mean, they didn't object.
All right, well, I understand. I'm going to order the LL2 be excluded. I'm going to sustain the objections to it, but we'll permit LL1 and LL3 to be admitted over defense objections.
Thank you.
1 and 3. All right.
You're done.
Yes.
Yeah, let me actually look. Is this the one? Which one's the one that you guys gave us in reciprocal discovery?
Diamondback TV 15.
Okay.
Yeah, that's the one.
Yeah, okay.
I have the good luck to have this go off when the jury's not here. All right.
Your Honor, just for purposes of the record,
Yeah.
quadruple L1 was provided to us by the defense in reciprocal discovery.
Understood.
Just for purposes of the record.
I think I'm admitting 1 and 3, aren't I? And that's
Yes.
it, yeah.
Yes.
And sustaining objection as to 2.
I didn't offer that,
I did not say you did.
just to be clear.
All right. Do we have others?
Quadruple M.
Quadruple M?
Yes, Your Honor, what we've got here, starting off with quadruple M number 1. That is a ATF E-Trace that Special Agent Scheider testified to, and that does several things. The Georgia 4th over there testified that he and his dad were up at the Columbus Gun Show at Western Mall and had to go up there and get the Kel-Tec PMR 30. That shows a purchase date of 10/31 of 2015. Moving on to
131. January 31st.
January 31st of 2015, Your Honor.
How many quadruple M's are there?
4 of them. That's the first one.
Are these, do these show purchases all dated the same day?
Yes, Your
131
Honor.
of,
Yes.
131 of, what was the date? 131
Of
Sep-
2015.
2015.
You know what they do? I'm gonna move to actually number 4 because it adds. I'm sorry, it goes up to 5. I'm gonna move on to. I'm gonna jump over a couple of them. I'm gonna go to quadruple M number 4. That is the 4473. You've seen a couple of these before. That the name of the defendant. and it refers to the Keltec PMR 30 that he testified he went up to the Columbus Gun Show to purchase. The second page of this indicates if sale of a gun show or other qualifying event, name of the event, Westland Gun Shows, Columbus, Ohio. And the date on this is January 31st of 2015. That does two things. He testified to buying that weapon there. He testified to being at the gun show. Moving on to quadruple M number 2, that is a 4473 in the name of Edward Jacob Wagner. That has him, and it doesn't indicate that the type of gun other than a long gun. It doesn't say like Beretta or whatever, but that is the date on this is January 31st of 2015, and the event is the Westland Mall Gun Show in Columbus, Ohio. That puts him and the defendant at the Westland Mall Gun Show on the same day buying guns. Additionally, moving on to quadruple M number 3, it's the ATF E-Trace on a Walther Colt railgun that just happens to be our murder weapon, and it was purchased by Edward Jacob Wagner from a dealer named Kyle's Gun Shop, and that was January 31st of 2015. Moving on to quadruple M number 5, that was the Westland Mall vendor list for the gun show for the weekend of January 31st to February 1st, 2015, and it indicates you have better eyes than I do, but it indicates that the vendors at the Westland Mall Gun Show on January 31st is Kyle's Gun Shop, and it has the same address, everything, 8527 Pender Drive, Cincinnati, Ohio, Your Honor. So what all of these do is place the defendant and Edward Jacob Wagner together at the Columbus Gun Show while Edward Jacob Wagner is purchasing the murder weapon.
Did you say there's a fifth one there too, or not?
Yes, the fifth one actually, what I just went over, that's the vendor list.
Oh, well,
So we're looking at 2 E-Traces and 2 4473s and the vendor list, Your Honor.
now, on behalf of the defense.
Those are all testified to by Agent Shire yesterday without objection.
And also by the defendant, all but the vendor list and one of the applications for, yeah, E-Trace. The 1911, yeah.
Exhibit quadruple M2. This is a firearm transaction report purportedly from Edward Wagner. Although he testified he did not identify this document, did not identify his signature being on this document. Whoever prepared this document, we had no idea. He didn't come in here, authenticate that, state that they would even prepare this report in the ordinary course of business. We would ask that this one be denied if not admitted pursuant to the hearsay rule and admissible hearsay. As well as the same argument in regard to quadruple M3. This is the firearms trace summary. Here's a document prepared by well, I don't know who it's prepared by, but at the top it says Westland Mall vendor list January 31st to February 1st, 2015. No representative from Westland Mall came in here. this is being offered for the truth that all of these names were purported vendors at this event. However, there's been no testimony whether, how this document was prepared, who put it together. Is this prepared in the ordinary course of business? It's certainly being offered for the truth that these are the vendors there. And I might add that the question about this document is on quadruple M1, which is a firearm transaction report, has a dealer information of Zachary Hess, who's not on this Westland Mall vendor list. And so, therefore, again, without sufficient foundation, authentication, nobody came in here and testified that they prepared this in the ordinary course of business. This one should not be admitted as being in violation of the hearsay rule.
The quadruple M1, just to make sure the court understands, this is for the Caltech PMR 30 22 caliber. I believe this has no connection to crimes.
The defendant testified to going up there and buying the item that refers to at the Columbus Gun Show.
We don't.
It's on the gun list as well, Your Honor.
Yes.
It's on the gun list, and he indicated that he bought it for his father at that gun show. In fact, he claimed they went to the gun show just to purchase that item. And these certainly are documents prepared in the regular course of business, and Agent Scheider indicated that he obtained these documents during the course of the investigation. If they want me to bring in other witnesses, we'd be happy to do so.
Well, we're objecting. Whoever they want to call, they can call.
Okay.
I don't believe there'd be an objection, Your Honor, if it didn't put the defendant up there with the
Somebody's got to come in and they've got to
co-defendant
testify
buying the
about
murder
it.
weapon.
And they had Edward J. Wagner on the stand to present these documents. Was this your signature? Is this the gun you bought? And they didn't do that.
That's
Instead,
because your
they wanted to
client
cut
didn't
back.
admit to being there with him at the time.
Do we have another one up there? I've got one.
Oh, yes. It's quadruple M. We're going to weigh the prejudice of these particular documents as well.
All right. So why should the court find or believe that these documents are what they purport to be?
I think that burden is upon.
Well, I mean, that's why I guess I'm asking the state. Why should the court feel that these documents are?
First of all, with respect to the E-trace, Agent Schneider testified. So we use those documents to cross the defendant, and then we put Agent Schneider up to talk about how he goes about getting those documents. And he talks about, in the ordinary course of their business, they run these E-traces through the ATF database, and they rely on those E-traces as reliable information with respect to firearms that are found at scenes, and they run up their social security numbers. So he laid a foundation for.
These come from a database. Tell me about the database again.
So again, he talked about the fact that it's an ATF database that when they recover a firearm at a scene, they're able to put that serial number with respect to that firearm into that database, and that is kept and maintained the ordinary course of ATF business. They then kick that back, a result back to the agents or the analysts, whoever.
Well, let me ask defense here this minute. You don't feel the ATF database is sufficient, if it comes from there, that it's sufficient to create some authenticity to these documents?
I believe that's what's required. Somebody from the ATF would have to come in here and say, this is what we do in the ordinary course of business. This is a record we created.
But that database, doesn't it exist for law enforcement to use? Isn't that why it's there?
For the ATF, that is correct. I mean, just because they use it for that purpose doesn't mean that there's an exception to the hearsay rule. But actually, whoever creates that business record has to come in and say, yes, we do this in the ordinary course of business. I mean, we don't relax it or water it down. In fact, there's a specific rule on police reports. I mean, this is akin to a police report, that police reports are not to be admitted.
This isn't a police report.
It's not, but it's a report prepared by a law enforcement agency.
Right.
Which law enforcement agencies do in the regular course of business. However, there's a specific rule that reports prepared by law enforcement agencies are not admitted.
It's a report relied upon by BCI and law enforcement agencies across the country in the ordinary course of their business. Whether or not the rest of the arguments are weight arguments, but Agent Scheider testified about how they go about tracing these guns, the database that they use, and again, how that's relied upon on what they do on a day-to-day basis at BCI. After that, the attack on, well, how do you know whether the correct information is put, that becomes a weight argument at that point.
The court will admit 1 through 5, quadruple M, 1 through 5, over defense objection.
If I could just make this point, just for the record, to understand your ruling, I just want to put on the record that my objection is pursuant to hearsay rule 803 subsection 8, which is public records and reports. Records, report statements, or data compilations in any form of public offices or agencies setting forth the activities of the office or the agency are matters observed pursuant to duty imposed by law to which matters that was a duty to report, excluding, however, in criminal cases, matters observed by police officers and other law enforcement personnel. Those reports should not be. Thank you.
Is there anything further today? We had these two, I think, we were going to look at.
Yes, there's
280.
two that are right behind this.
There is, I think you may have spoke of George's. There's also one with Edward J. Wagner. I'm not sure if the court ruled on that one. It's a firearm transaction report with his signature. He may be safe with his signature.
1 through 5, I believe you admitted, is what I heard. So,
Yes.
Submitted everything.
1 through 5.
thank you.
Quadruple B.
Your Honor, you had asked to see the timeline associated with safety of the quadruple B. Oh, one second.
Which one is it?
Quadruple F.
This is the merge.
Just can't recall.
Oh, yes, that's another one. Counsel, you've reviewed this from
We have, yes. It's just a compilation of the evidence that's already been admitted. I don't understand why the state needs to pluck out what's already been admitted to spoon-feed the jurors just these particular things. This is just like a listening aid. The jurors need to go and they need to inspect the actual records to put the purchases in context. You'd object to this.
I understand the reason the state's offering this, but I'm going to sustain the objection to it. I think it could be used as a closing argument document or something of that nature. Can be referred, you can refer to these purchases in your closing argument and the timeline of them. but I'm going to sustain the objection to this particular thing being used as an exhibit to go back to the jury.
May we take a break for a few minutes?
Well, I mean, yeah, I
Or we
mean,
move on to anything else?
Are we done?
yeah, we're done.
And we pop off the record.
Judge, do you happen to have a list, or could we get a list to show what has been admitted?
I don't have one that anybody could make any sense out of but me. We do need to have something.
We will get one typewritten up, Your Honor.
Okay, all right.
So that it's very clear and concise, and we already indicated to counsel that these will be put back up under lock and key, and then before they are officially admitted to the jury, before the jury retires to deliberate, both parties will re-inspect to make sure that nothing goes back to the jury that's not been properly admitted by the court.
We do need 288K and L.
Yes.
We need to resolve those two issues too. Here's
Yes.
quadruple F.
And Your Honor, I'm going to have to speak to our court reporter about some of that before I can make a complete argument on that as to 288. But then we also have two exhibits back there that we need to redact confidential information about being on the triple M and then the financial records triple C remedy.
This, we could go off the record on this. I'm just scheduling it. Do we anticipate additional witnesses yet? Do we know now?
Yeah, that's why we need a break, Your Honor.
Oh, okay.
Yeah, I mean, we can talk about both options.
Yeah.
I mean, both alternatives.
Yeah, Judge, we had had some discussions on it.
We're all done?
Yeah, we're off the record. Maybe we could do this in chambers, some
Yeah.
scheduling issues.
All right.